You spend weeks building software, designing a brand identity, or drafting architectural plans. But your true financial asset is the bundle of underlying rights attached to that work. Handing over the final files to a client doesn't automatically mean you get paid for the intellectual property. To monetize the actual creation, those rights must be legally transferred. Think of this animated diagram as your two main paths. On the left, selling a house. You hand over the deed, collect the money, and walk away. On the right, renting an apartment. You sign a lease, someone else uses the space, but your name stays on the title. In intellectual property, these translate to an assignment and a license. How you execute this transfer dictates your entire business model. It separates building a long-term portfolio of assets that generate recurring revenue from permanently giving away control of your best work. Many creators assume that just because they made an original work, they automatically qualify for highly favorable copyright tax regimes, like the 15% withholding tax available in Belgium. That is a dangerous assumption. Tax law follows civil law. If you don't have a legally flawless civil contract proving exactly how those rights moved from you to the client, the tax optimization will fail completely during an audit. Deciding between an assignment and a license is the primary strategic lever you use to control the future of your creative business. This matrix breaks down what you trade away. The assignment column represents the definitive sale of your rights. The buyer becomes the absolute legal owner. It's a clean break, but permanently strips your ability to reuse or profit from that work. Shifting to the license column, we look at the rental model. You authorize specific uses for a set time, but remain the absolute owner. Notice the reversibility loop. You get your rights back when the term ends. The catch is the administrative burden. A license requires strict ongoing management and contract tracking to ensure your partner stays within the agreed bounds. The paths diverge clearly here. You are choosing between the finality of a sale and the ongoing control of a lease. Neither option is inherently wrong. The right choice depends entirely on how much future control you need over that specific asset. Regardless of which path you choose, there is one piece of copyright that never transfers. This slide details your moral rights, specifically the rights of paternity, delegation, and integrity. As the text states, these are inalienable. This means you always maintain the right to demand your name be attached to the work, and you can block any modifications that would damage your professional reputation. However, moral rights are a shield, not a sword. You cannot use them as a backdoor to claw back commercial control or demand more money after you have legally sold the patrimonial rights. That brings us to the mandatory guardrails governing the actual written contract, transferring those patrimonial rights. The law requires high precision. Your contract must explicitly list the allowed modes of exploitation, the exact duration, the geographic territory, and the corresponding remuneration. If you fail to detail these points, courts interpret any vagueness strictly against the buyer and in favor of the creator. There is also a strict protective rule against blanket land grabs. Any clause claiming rights for unknown future modes of exploitation is automatically nullified. Vague, verbal, or lazily drafted contracts invite legal disputes and cause your tax strategy to collapse during an audit. This decision tree maps the legal mechanism to your specific profile. The primary question is, who are you transferring the rights to? Following the path to an external client, the most common and practical outcome for a commissioned professional or freelancer is a partial assignment. A partial assignment transfers only the exact rights the client paid for, like the right to use a specific logo design exclusively in the European market for 5 years. This satisfies the client's need for security and ownership of the final product, while legally protecting your underlying frameworks, drafts, and the ability to use your core techniques for the next client. Now let's trace the path for the founder-creator. If you are transferring IP to your own business entity, the optimal mechanism is usually an exclusive license. Here, your company gets the legal right to exploit the software or design to generate revenue, while you, the individual creator, retain ultimate ownership of the asset. Structuring it this way allows you to extract value from your company in the form of recurring royalties, which often benefit from highly optimized tax rates. Because you are signing a contract with yourself, tax authorities scrutinize these setups heavily. The paperwork between you and your entity must be absolutely airtight to survive an audit. Whether you are dealing with a demanding client or your own corporate entity, Choosing intentionally between a partial assignment and an exclusive license separates a one-off paycheck from a sustainable portfolio of assets. Defaulting to a standard contract template often means giving away rights you could have kept. Deciding between finality and control has to be an active, strategic choice. Take a close look at the contracts you currently use. Check the wording carefully to see if you are selling your rights when you should really be renting them. Finally, remember that the mechanics of copyright and tax law are highly specific to your jurisdiction. This is legal information, not legal advice. Always consult with a specialized IP attorney or accountant before restructuring your business.